everyone, and good afternoon, everyone, and welcome back to our weekly series on insolvency and bankruptcy code. Today would be our 20th episode of this series, and we'll be continuing the topic uh, meeting of CoC and the powers of the CoC with respect to IBC and the whole IBC process. So I'll share my screen, and I am with me. I have Advocate Aditya Gauri and Advocate Shalya Agarwal. Both of them will be, uh, of course, working with me and talking about the various topics that we have on this PPT. And we will continue where we left previously. Previously, to give a quick recap, we had talked about the various powers of the CoC, and it included various judicial pronouncements on how the commercial wisdom of the CoC, what is not a commercial wisdom, what is a commercial wisdom, and we talked about the decision of CoC to choose between liquidation and a resolution plan, and we will continue that discussion today. So we understand that this is where we stopped last time, where we talked about limited jurisdiction of Honorable NCLT and NCLAT to intervene upon commercial wisdom of CoC. So there have been various cases, various case laws. I think going by each and every slide individually may not be very beneficial to talk about the limited judicial review which is available with NCLT and NCLAT. The judgment and the various idea now is, and the summary of legal position today is that it has to be within the four corners of section 30 subsection 2 and section 32 read with section 61(3) of the code, and such review can in no circumstance trespass upon commercial decision of the majority of the CoC. So the CoC's supremacy in taking a decision has been established. Various cases where CoC has approved a resolution plan, even if the plan gave CoCs, gave the financial creditors or other creditors an amount which was less than the overall liquidation value of the company. Even then, it has been accepted that they have the powers to approve a resolution plan which offers less than the liquidation value. In other examples, maybe Shalya and Aditya can also share some other examples where NCLT or NCLAT has said that even if this decision is taken by CoC, it is supreme. Then it comes to the ultimate discretion of what to pay and how much to pay. So as long as the compliance with the requirement to pay the liquidation value to the dissenting creditors is taken care of, there is no other restriction on the CoC to say that how much will be paid to all the creditors. But then, yes, whenever they are passing a resolution plan, they have to, of course, look at how they are maximizing the value of the assets of the CD and also preserving the going concern nature of the company or of the CD. So this judgment, K. Shashidhar versus Indian Overseas Bank and others, is a 2019 judgment from Honorable Supreme Court. And here, the observations of the Supreme Court were that the legislature had not endowed the AA with jurisdiction or authority to analyze or evaluate the commercial decision of the CoC, much less to inquire into justness of the rejection of the resolution plan by dissenting financial creditors. So there is an intrinsic assumption that financial creditors are fully informed about viability of the resolution of the corporate debtor and the feasibility of the proposed resolution plan, and they act on the basis of thorough examination and assessment of the proposed resolution plan. And the legislature consciously has not provided any ground to challenge the commercial wisdom of the individual financial creditors of the collective decision before adjudicating authority, which is not justifiable. Thus, this case categorically restricted the role of AA when dealing with a rejected resolution plan, emphasizing that when assessing the merits of a resolution plan, reliance is to be placed on commercial wisdom of the creditors. To the extent, last time Anil sir had shared a case law where the CoC first decided to approve a resolution plan and the plan was pending for approval before NCLT. and later decided that it would be better to liquidate the company when the resolution plan was not getting as long as the resolution plan did not get approval from NCLT, then they subsequently decided to get the company into liquidation. So even that change of mind was approved by the courts. SR Steel India Limited versus Satish Kumar Gupta. Here again, the AA has limited power of judicial review. That was what was held by Supreme Court. And under the code, the AA has the jurisdiction to merely decide whether a resolution plan passes muster under the code, thereby reiterating the notion that the real power to approve a resolution plan lies in the hands of the CoC. So, who all are responsible to make sure that the resolution plan is compliant with the code? So the first responsibility comes to the insolvency professional. Then the CoC is again responsible because they wouldn't be wanting to waste everyone's time by approving a resolution plan which is not compliant with the code. But the primary duty with respect to compliance of the code remains with the IP. And then subsequently, the NCLT verifies that yes, due process has been conducted, everything is complete with respect to the approval. So again, Maharashtra Seamless Limited versus Padmanabhan Venkatesh and others, again in a Supreme Court judgment dated 2020, where the Honorable Court considers whether the adjudicating authority could reassess a resolution plan approved by the CoC. So observation were that in this respect, it was expressly held that AA ought to cede ground to commercial wisdom of the creditors rather than assess the resolution plan on the basis of quantitative analysis. So they left it to the CoC. Also, I would like to comment at this point that CoC, whenever we see CoCs approving various resolution plans, a lot of weightage presently is on how much is the CoC getting paid, what are the tenures of that amount being realized. And IBBI in a recent statement had again shared that they're looking at even uh, more freedom with respect to how resolution plans can be structured. Resolution plans in the present regime are centered about repayment to the financial creditors, repayment to the operational creditors, when the repayment is coming, how much is coming. But there might be other innovative ways of restructuring an asset through a resolution plan, and that is also possible where the existing debts continue, they start getting serviced, and so that is also very much possible. So IMR Metallurgical Resources AG versus Ferroalloys Corporation Limited. Here again, the commercial wisdom of the CoC is paramount, is what it was said. It was clarified that the approval or rejection of resolution plan depends on the commercial wisdom of the CoC. And the power of AA under the code is limited to matters covered under Section 32 of the code, and so on. So fair value is so when choosing between I guess we can skip this slide, but the idea is that when CoC is deciding between resolution plan and liquidation, they have to look at the fair value as well as the liquidation value. So the resolution plan must have the following. What all? Payment of insolvency resolution process cost in priority to other debts, repayment of debt of OC in such manner as not to be less than the amount payable to them in event of liquidation of CD, management of CD after approval of resolution plan, implementation and supervision of resolution plan, and does not contravene any provisions of law. So where the resolution plan is approved by more than 75% votes in the CoC and is compliance with the plan, they would approve this NCLT would approve the plan, which should be binding on all stakeholders, including CD guarantees and so on. So relevant sections and regulations dealing with concept of resolution plan. So maybe Aditya can take this slide, and I will keep adding wherever I have something to add to whatever you are saying.
Sure. So Section 5, Subclass 26 defines resolution plans, which means a plan which is proposed by the resolution applicant for insolvency resolution of corporate debtor as a going concern in accordance with Part 2. Now, there was an explanation to it that for removal of doubts, it was clarified that a resolution plan may include provisions for restructuring of the corporate debtor, including by way of a merger, amalgamation, and demerger. Now, there have been cases where we have seen mergers and demergers proposed in the resolution plan itself and which were duly approved by the adjudicating authorities. Then 5 subclause 25 defines the resolution applicants. It means any person individually or jointly who submits a resolution plan to the RP pursuant to invitation under 25(2)(h). Then 30 subclause 2 provides that the resolution professional shall examine each resolution plan received by him and would present before CoC all those plans which conforms to section 30 subclause 2. 29.2 provides that the RP is under obligation to provide relevant information as per the IM prepared to all resolution applicants, subject to certain undertakings to be given by the applicant. We can move on. Get a Then there is section 30 subclause 5, which provides that the resolution applicant may attend the meeting of the committee of creditors in which the RP of the applicant is considered. However, the resolution applicant shall not have a right to vote at the meeting of committee of creditors where the RP is being considered unless the applicant is a financial creditor. I guess this is where the resolution applicant is allowed to come and speak to the committee of creditors directly and negotiate on the plans and renegotiate if there are certain anomalies being found by the creditors. Then there is section 30 of the Insolvency Bankruptcy Code and Regulation 38, which provides for the mandatory contents of a resolution plan, which in effect are again verified by the resolution professional. Then there's section 31 and regulation 39 of the CIRP regulations, which provides for approval of resolution plan. Then 32, which provides for an appeal from an order approving the resolution plan. And then there is the regulation 37, which provides for various options and measures while making a resolution plan.
So great. So I think what we need to understand now is that yes, one, the resolution plans can be innovative. Resolution plans can talk about restructuring, can talk about other ways of how a resolution can be achieved. But yes, still when we look at our experience in dealing with COCs, 95% of the discussions in the COC and between the COC and resolution applicants is with respect to increasing the amount that the resolution applicant is paying, or increasing the present value of the amounts by making the amounts payable sooner. The main reason behind that is that whenever any case is under insolvency, the banks have already provisioned for that asset, and in case the provisioning is required to be reversed or provisioning is required to be finished, then the banks need that money to come in. And in case the money does not come in through the resolution applicant, then the asset remains a provisioned asset in the books of accounts of the banks. So that is one of the major hurdles, that when a resolution applicant or resolution plan is approved by CoC members, which permits the resolution applicant to continue the company with the same bankers and continue the credit and continue servicing the credit, then it results into perhaps a longer period of time for the banks to reverse their provisioning. So going forward, maybe I can take this up where we can say that who can prepare and submit a resolution plan. So we are very sure that almost everyone and anyone can become a resolution applicant as long as they are meeting the eligibility criteria, which is stated or fixed by the CoC. So how many resolution plans can be prepared and submitted? There are no limits on number of resolution plans which can be prepared and submitted by different resolution applicants, and limit on number of modifications to resolution plans is now there. Now it is not more than once. So regulation 39 1A talks about this now. This was a recent modification to limit the time spent by CoC members or by the resolution plan is negotiating on the resolution plan value. Why is this important? It is important because our experience at AAA with dealing with CoC meetings and dealing with resolution applicants is that if the resolution applicants are confident that are shown the picture that the value that they are giving is open to further negotiation, then they will never give their full value at that point in time. They will hold on to some value that they would think they will like to increase at a later date. Also, in many cases, it it helps when there is competition. So say there are, let's take an example, there are 4 resolution applicants. All 4 of them are sitting in the room, and there is a scenario created by the CoC and the resolution professional that today would be the last date on which the negotiations would happen, and after which negotiations will not happen. The H1 will proceed and the H1 will take things forward, or the CoC will start voting on the plans that are submitted. The CoC naturally, after the recent amendment, has to vote on all the plans submitted, but the CoC will keep the H1 as H1, and the CoC will therefore vote only, therefore start voting immediately. So in that scenario, there are 2 things that happen. One, because of the fight between the resolution applicants, there is a strong possibility that the value gets increased because of the competition. And we have seen that happening in the various auctions that we do at the time of liquidation, where when there are 5, 7, 8 people, then everyone is trying to fight time as well as each other with respect to giving the highest value possible, as long as that value is within the number that they have in mind that they would like to go up to. So competition is a major driver, and once if competition at this kind of a system is not this kind of a interactive, or this kind of a deadline is not produces result, then almost nothing else produces that result. So the resolution professional may decline acceptance of any further resolution plan in case not submitted within 30 days before expiry of period limited under section 12 for completion of CIRP. So duty of resolution professional to invite resolution plan, RP to invite prospective resolution applicants, eligibility criteria to be laid down by him after the approval of CoC, having regard to the complexity and scale of operations of the business of the corporate debtor and such other conditions as may be prescribed by the board, to submit a resolution plan or plans, and RP to present all resolution plans at the meeting of CoC and put the same to vote of CoC members. So the resolution plan has to be based on the information memorandum. That's what 29(1) says. And for the purpose of this section, all the relevant information that is available in physical and electronic form has to be provided by resolution professional to the resolution applicants. The information memorandum is a very, very important document. If the information memorandum does not have enough information for the resolution applicant to decide on or arrive at the value which he will be able to realize from the CD's assets or from the CD's control, then it would hide a lot of things. So for an example, say the balance sheet of the CD does not show an income tax refund which is claimable, say of about 2 crore rupees, because the company had prepared financial statements assuming that this 2 crores is not receivable. And the information memorandum also say does not have any facts with respect to this case which is being fought by the CD. Now, in that case, this 2 crore value, which might otherwise be coming into the CD, would not be available. This information, in absence of this information, nobody will take that into account when they are producing a resolution or filing a resolution plan. So therefore, all information with respect to various litigations, with respect to any encumbrances on assets, with respect to all the details of the CD, the details of the employees working for the CDs, their salaries. So it has to be a very, very detailed information memorandum for a quality resolution plan to come in. Also, in many cases, what happens is that the information memorandum is sent, the resolution applicant files the resolution plan, and at a later date disputes with the resolution professional that enough information was not shared in the information memorandum, and therefore he would like to withdraw his resolution plan. So there, in case of any major error or major amiss in the information memorandum with respect to any information that is very, very important, there again the dispute can be prevented by having a proper information memorandum. So of course there is a full list what all information needs to go into the information memorandum. But our thought process has always been that the resolution professional should rather prepare the information memorandum, taking into view that any question that might arise in the mind of the resolution applicant should be answered readily in the information memorandum without the resolution applicant having questions on those aspects. So the resolution professional shall provide to the resolution applicant access to all relevant information in physical and electronic form. Of course, we have talked about what is relevant information. The RP shall prepare an IM containing such relevant facts, and basically all the relevant information should be available. So that's how it is. Mandatory contents of the resolution plan. So section 30 of IBC and regulation 38 talks about how the shall provide for payment of resolution. So these are all parts that need to be taken care of in the resolution plan. And basically, I believe we already understand this, so we can skip to the next one. Of course, we know that liquidation value due to operational creditors has to be taken into account in the resolution plan, and liquidation value for payment of shall provide for payment of liquidation value due to operational creditors. So again, that's something that we have talked about. This part is important. Shall provide for payment of liquidation value due to dissenting financial creditors, identify source of funds for this, and provide for payment before any recoveries are made by financial creditors who voted in favor of resolution plan. So how do you, what do you do as a resolution professional, as a CoC member, to ensure that your liquidation value or liquidation value of the assets which are available with you is correctly computed? Because the CoC members presently get the full report of the valuer only on submission of the disclaimer that the undertaking that they will not be, of course, they will be adhering to confidentiality norms, and after that they can get the access to the valuation report, and the valuation report will then give a value to the assets, various assets of the CD, and the banker or the CoC member can then subsequently calculate the liquidation value, which is ascertainable or allocable to the said financial creditor who is dissenting, or who or every financial creditor, so that the financial creditor can understand that what is the value he would get in case liquidation is proceeded with. Because this decision to approve the resolution plan or not to approve the resolution plan, or dissent as a financial creditor, would then determine that what value will the financial creditor or the operational creditors get in case of the two scenarios, and that would be a major decision maker in the whole conduct of operations. So one of the important things to do is that wherever different assets are secured for the various facilities availed from financial creditors by a CD, then the value should be available based on the different security interests created by the CD for the CD. So of course we have talked about this. Then term of the resolution plan and its implementation schedule. So shall provide for term of the resolution plan, its implementation schedule, shall provide for period during which the plan would be implemented fully, no limitation on number of years of any repayment plan. Number of years would depend upon the source of funds for resolution plan. And in case of certain plans, the term can be few months, example, sale of non-core assets, one-time settlement, etc. So further, the board of directors of the corporate debtor, reinstated or not, or without any mediation in the structure of the, without any change in the structure of the board, financial and other powers of the board can be restricted. So key decisions are taken with prior approval of CoC or any person authorized by CoC. Handling over management to someone else who is considered more capable. So all these things can be part of how the management or the affairs of the CD can be done. Then any professional can be appointed for the implementation of the resolution plan. Then auditor or internal auditor can be changed or appointed afresh. So these are various provisions in the resolution plan, which we have learned over the period that these are very important provisions that need to be taken care of. So the resolution plan shall not contravene any law, otherwise it might not get approved. No proceeding shall be initiated against IRP or RP for any action of the corporate debtor prior to commencement date. No consent of members or partners would be required for provisions in plan and for implementation for such. Otherwise, the approval of members or partners would be required. Any provision in resolution plan which requires any consent from JV partners, etc., or violates any clauses of shareholders agreements, they shall take effect without any such consent. So all these provisions are already part of the act, part of the law, and these are available. So let's quickly talk about evaluation of a resolution plan, examination and evaluation of resolution plans. So first of all, the process involves whether the prospective resolution applicants, whenever they they file their expression of interest in the form and through the process which the resolution professional is conducting, they have to meet the eligibility criteria. And the eligibility criteria is important. Eligibility criteria we can discuss in a while, that what can be the eligibility criteria which make a difference, which make only serious people come into the resolution plan. And then non-eligibility. So if any 29A has also been seen while issuing final list of PRA, revisit is required, as the names of proposed directors and shareholders and management will be revealed in resolution plan and not in EOI. Then verification of mandatory contents of resolution plan. So that is required as part of the process. And mapping of the compliances of terms and conditions of Rfrp with the resolution plan, verification of submission of duly sworn affidavits along with resolution plan, amount to be distributed under resolution plan is fair and equitable to such creditors, examination of feasibility and viability of the resolution plan by the CoC. CoC will also examine if distribution proposes taking care of order of priority and value of security interest of various financial creditors. Now let's understand the role of CoC in resolution plan. So the responsibility of approving a resolution plan rests with the CoC, which will approve it with not less than 66% voting in favor of it. And on crucial power of CoC, one crucial power of CoC is to consider and then approve a resolution plan with respect to the company. And the code under section 34 obliges the CoC to assess the viability and feasibility of the resolution plan. And the 66% voting is done based on that. Then, of course, there is an evaluation matrix, which is pre-approved by the CoC, and that evaluation matrix is then based on the evaluation matrix, various markings and various points are issued to various people. Resolution plan to be based on IM. So IM is a document which contains all the relevant documents, all the relevant ideas. So let's take some examples, some illustrations where we say that suppose that company A, which manufactures steel, is undergoing insolvency. So let's assume that a bigger steel manufacturer, company B, wants to submit a bid. So the company B will check details about the company A, like assets owned, supply chain, brand value, and so on. And then all the information that is needed to value the debtor and submit a bid might not be available in public domain. Therefore, the IM in IBC is needed to provide such details about the company. Maybe Shalya, you can take up the contents of an IM quickly, and then we can take it forward.
Yeah, so as discussed, information memorandum is the most important document basis which the resolution applicants submit their plans. So what all content should be there in a resolution plan is that the description of all the assets and liabilities of the CD should be mentioned, which should include the accusation date, the depreciation, book value, cost. The audited financial statements for at least last 2 financial years should also be mentioned. And then the final and provisional annual statements for current financial year. Now this is prepared by the RP for the current ones. Then details of the operational debt and financial debt also has to be mentioned. Basis this, only the resolution applicants will ascertain that what amount they are paying and how much will be their repayment plan. Then there are times when the directors have given their guarantees, personal guarantees. So even the guarantees have to be given has to be stated in the IM. Then details of the shareholders, the partners who hold more than 1% stake in the company, and any balance payment that has to be received or which they have to pay to the related parties, it needs to be mentioned. Then details of the workers and employees who are working with the company and what are the debts that has to be paid to them. Then all details of any investigations or litigations which are pending against the corporate debtor, that has to be mentioned. Yeah, so these are the important contents which are to be mentioned in the information memorandum, basis which a resolution applicant will provide their plan.
So I think then we have audience of information memorandum. So after the memorandum has been built, it can be shared in physical or electronic form. And the important stakeholders who use these details are, of course, all the members of CoC. The information is shared with its creditors so that they're aware of the financial and commercial position of the debtor. Any creditor can request for additional information if needed. And IM is a key document on which a resolution plan is prepared. Hence, the CoC would devote maximum time on the IM. And the prospective resolution applicants are, of course, those who are having access to the IM. Now, some of the amendments which are proposed now are that one, the resolution professional has to now make sure that the IM contains the details which are, or IM is built based on the details which are available from the CoC members. So the present situation is that very rarely we find that CoC members are able to share important details which are available with them, because since the time they might have sanctioned some loans to the company, the volume of information which is collected by the CoC members on any loan application is pretty massive. And it is now believed and it is now popularly understood that why shouldn't all that information be available to the resolution professional for incorporation in the IM? Because even if that data is historical, some of that data might be operational data, might be data which helps the resolution applicants understand the company better. So that is one important thing that is part of the IM. Then second thing is that it is now also stated that in the new draft regulations that the IM should also contain those liabilities or list of those liabilities which are part of the books of accounts available with the CD, but where the but where the creditors have not filed their claims. So even those amounts are now required to be stated in the IM, so that the resolution applicant can choose how he wants to deal with those liabilities. Negotiation with prospective resolution applicants. The lenders will have all the rights to proceed against the personal guarantors and corporate guarantors. The personal guarantors of the corporate guarantors will have no right of subrogation against the corporate debtor in case any amount is recovered from them by the lenders. And any amount recovered from application under section 43, 45, 50, and 66 would be allocated to lenders in a pre-decided ratio, and the corporate debtor would not be entitled to the same. RP will continue to pursue the applications, engage lawyers till the conclusion of applications, and any amount recovered from contingent assets would be allocable to lenders in pre-decided ratio, and any delay in approval of resolution plan by NCLT or because of litigation would not be used by RA to withdraw the resolution plan. So these are some tools or some items which must be mentioned or must be part of the resolution plan, because in case any of these clauses are not or are different in the resolution plan, then it can derail the whole resolution process. So the CoC as well as the resolution professional must make sure that these are compliant with. The additional CRP cost incurred during delay in approval by AAA will also be contributed by RA, as banks and FIs want fixed amount allocated to them for ease of getting approval and later implementing it. Any waivers sought by RA and approved by CoC, if not allowed by AA or any other court, will not be used as reason to withdraw the resolution plan. And force majeure clause in resolution plan need to be defined very carefully and should not have adverse eventualities of business and should be restricted to natural calamities only. So these are some recommendations based on the experience. The negotiation by the prospective resolution applicants, all the terms and conditions mentioned in the Rfrp and detailed EOI, if not complied by the RA, will stand waived and should not be used against the RA later. So specific resolution by CoC for that may be insisted by the resolution applicant. So these are some points which the RA or the prospective resolution applicant might try and enforce and negotiate with the lenders. Both the documents, Rfrp and detailed EOI, would be considered dead once the resolution plan is approved by CoC, and implementation would be done based on the terms and conditions mentioned in the resolution plan. The remedy available to RA should be stated in case of delay in handing over the business documents, satisfaction of charges, title deeds, etc. Then upfront payment can be provided against some conditions precedent to be complied and completed by CoC and the RP. Any additional creditors surfaced later would not have any impact on the total outflow of the RA, and then only the distribution between the existing lenders would change. Any additional amount required to be allocated to dissenting creditors would be allocated from the total resources offered by RA in the resolution plan. RA will have right to change structuring of resolution plan, example, debt equity ratio, continuing with the existing share capital or distinguishing it. So all these rights are normally negotiated by resolution applicants when they are completing it. Role of CoC and IBBI on use of Swiss challenge method. Swiss challenge method or any challenge method. So in CRP, it is popularly used to maximize the value which the CoC is getting from the resolution applicants. And in fact, we were doing a Swiss challenge method for one of the CDs where we are resolution professionals at AAA yesterday only, and that was that day before yesterday, and that was a very that step or that concept is very important to increase the value of which the CoC can get from resolution applicants. So creating a Swiss challenge method creates transparency, does not allow any disputes to arise later, then also adds in how it gets only committed increases in the resolution applicant process from the participants, and the whole process is then a very time-bound process, which allows a faster decision making, faster closure on how things can proceed. That's how it is done. So sub-regulation 3A provides that CoC shall evaluate the resolution plans received as per evaluation matrix, and thus the said regulation is silent on the exact method to be used for selection of the best resolution plan. So the CoC, once the CoC decides to use SCM, the first approved resolution plan may be treated as the base plan, and thereafter the details of the same are made public, calling for competitive plans within a specific time. Where a better plan is proposed, the proposer of the first plan is provided an opportunity to match the same. And due to competitive bidding, what happens is that the impact of using SCM is maximizing the value of assets under stress. So that's how. So if there are 3 bidders, let's say one bidder is the H1 as on date, as on a particular time. Now the opportunity is given to all the 3 resolution applicants to increase their bids or enhance their bids. So they would normally write it on a document, write it on a paper and say that, okay, this is what we are offering in this much tenure. and also for with respect to qualitative parameters, they would submit whatever they want to submit. And that way is that incremental gain in the resolution plan in terms of the amount that they are contributing, amount that they are adding to the resolution plan will then come in, and based on that, live update will be done to the evaluation matrix for all the three, let's say, resolution applicants to again declare an H1. Now the H2 and the H3 will again be asked to quote or increase their bid. So that's how the competition works, where the final H1 would then be finalized based on this process. So evaluation matrix, bid evaluation matrix. So I think we still have 20 minutes. We can take some questions. Let's try in case we have some good questions out here. Arun Srivastava ji is asking whether contingent liability to be shown in IM, and if audited accounts are not prepared for absence of relevant records, how to prepare IM. So I think now the law is very clear, and I think Aditya and Shalya will also agree with me that now there is a mandate on the resolution professional to update the books of accounts if the updated books of accounts are not available to him from the CD's management. And for that, it is now a requirement for the resolution professional to seek a budget from the CoC, approval of the budget, and then get the accounts updated till the CRP date. And beyond the CRP date, it is anyways the duty of the RP to maintain and keep the books of accounts of the CD while in CRP period. And that is, I think, what I would say. Contingent liabilities that are known to the RP must be part of the IM so that the resolution plan can contain the relevant clauses which can address those contingent liabilities so that the resolution plan is not affected, or the implementation of resolution plan is not affected after the resolution plan is approved. So that therefore it is very, very important. Then we have in case Srinivas Saji is asking, in case RA provides RP with less than LV, what will be the amount will get by the dissenting FC? So it is natural that in case, say, the liquidation value is say 50 crores and the plan comes in for 45 crores. Now this 5 crores gap, which is not coming to the financial creditors, it is very natural to understand that the resolution plan in this circumstance will be approved only if that CoC member who is losing the right to that 5 crore liquidation value is voting for the plan. Because any resolution plan will be approved only if the requisite majority of members are approving that plan. So there can't be a dissenting financial creditor who is getting less than the liquidation value. That's the whole idea. So we are saying that in this scenario where the liquidation value is more and the resolution plan is offering less, there is no dissenting creditor. All the creditors are approving the resolution plan and accepting that they will be getting less than the liquidation value and still going ahead with the plan. That is the idea. Praveen ji is asking, how do we evaluate assets under arbitration? So I believe when we do valuation for assets, we try and get all the documents at hand. And I believe both Shalya and Aditya will agree with me that as advocates, when they go through documentation that is available with respect to an arbitration matter, which is primarily the arbitration initiation process, then filing of claims, then counter filing of claims, then counter arguments being made by the other party with respect to those claims. And all these claims, all these submissions are made along with a lot of documents. So when somebody goes through these documents and understands the case, we normally as valuers gauge the value of the arbitration claim by understanding that what is the kind of supporting document or supporting material available to the or with the CD, so that the CD can ascertain or CD can claim the amount under arbitration. In case the contrary information is available, that counterclaims are rather more robust with respect to, say, the let's say the EPC, there is an EPC company under insolvency. Now the EPC company files an arbitration claim saying that this person or this contractee has this person who had given us a contract is not paying us this amount. In that scenario, only it becomes a productive scenario only if we have more claims than the counter claims. So that is the assessment that I believe we have to take care of. So in absence of, Naresh is asking, in absence of resolution plan, what if CoC defers repeatedly resolution proposed by RP to initiate liquidation resulting on expiry of CRP period? That what is the obligation of RP in case excess period beyond CRP is not allowed by AA? Can CoC authorize RP to issue EOI after expiry of CRP period and before initiating liquidation proceeding? Can CoC initiate fresh process of CRP after expiry of CRP period? What is your say, Aditya? What is your say, Shalya, on this?
I think in the absence of a resolution plan, if the CoC is deferring it repeatedly, so the code suggests that once the time limit, the prescribed time limit of 180 days and even extendable up to 330 days is over, the company, the corporate debtor would automatically go into liquidation. So that's one answer to this particular question. Then what is the obligation of RP in case excess period beyond CIRP is not allowed by the adjudicating authority? See, if the excess period is not basically allowed by the adjudicating authority, then again, as per the provisions of the code, it goes to liquidation. But it all depends on case to case basis that why the adjudicating authority has not allowed it per se. And that then the next question in the same one is that can CoC authorize RP to issue EOI after expiry of CIRP period? Now the CoC derives its powers from the CIRP process that is going on. So once the CIRP per se is over, so I think that the CoC cannot really, it is non-est in law and it cannot authorize the RP to issue EOI after the expiry. And can CoC initiate fresh process of CIRP after expiry of CIRP period? I think no, separate, if it has gone into liquidation, then not. If that CIRP has been withdrawn, then maybe yes. In some cases, we have seen when the CIRP is withdrawn and then the members or few members of the CoC would come back together and initiate fresh CIRPs against them. But nowhere in the provision of the code does it say that after the process of CIRP and the time limit being over, the fresh process can be started, subject to the conditions there were some certain genuine defects and anomalies in the conduct of the CIRP process.
So I think you're absolutely right that this is how the CoC or the RP would have to say that the time period is supreme and the time period is duly stated in IBC. So unless and until there is an exclusion period or exclusion because of some litigation or some other applications that can be filed to extend the CRP period, the CRP period is of essence. And therefore, there are also now proposed regular amendments because the normal delays in CoC, that normal delays in resolution CRP period that have been seen are on account of litigation. Maybe we can't stop that. But CoC delays with respect to correcting information, non-cooperation from the various, the management of the CD, all those things can be kind of dealt with through information coming in from the CoC members. Then we have Mr. A.K. Parmar asking that since all the compliant resolution plans are put to vote, then what is the relevance of evaluation matrix? So I think what I need to say here is that now when all the resolution plans are put to vote, the evaluation matrix is still important because the evaluation matrix is a pre-decided tool for the CoC members to rate and evaluate that which of the resolution plans is having a better score. So because we have seen that the CoC members are also required to get approval from their head office, they are supposed to recommend a resolution plan which they favor, and therefore a resolution plan that they want to be recommended and seconded by their senior authorities, which is also H1 as in terms of the evaluation matrix would make a more sense. Would make more sense. And in case the CoC members want to make a deviation, then they eventually would have to give a reasoning on why they are choosing the H1 or the second place scorer to then take the company or their resolution plan. Why is that being approved? So therefore, the evaluation matrix is still important, because the evaluation matrix, the H1 in the evaluation matrix will still have will have an easier way to approvals from the CoC. Praveen Kujainji is asking that when CRP is withdrawn due to settlement and settlement fails in due course, whether CRP resumes automatically. I think we are discussing a very different topic today. So I think we can skip this part. Then Mr. Parmar is asking tiebreaker criteria in case two plans get the same percentage of vote is supposed to be decided by CoC. At what stage tiebreaker criteria is to be decided, whether before the RA submits the plan or later? So I think the tiebreaker criteria is something that ideally should be decided prior to the two resolution plans coming into competition and actually getting the same amount, same score. So tiebreaker, however, when you talk about a Swiss challenge, when you're actively negotiating with many people, all the resolution applicants, the tiebreaker is normally then also taken care of through negotiation and asking one of the two one of the people who are in tie to increase their or to make their resolution plan better. So let's go back to a slide now, and I think we can understand. So sample evaluation matrix was released, and I think we can quickly talk about this. So experience of resolution applicant in sector on which resolution plan debtor is operating. So these are some qualitative parameters on which can be incorporated in the evaluation matrix. And it can be acquisitions made by the RA in the immediate 5 years, financial strength of the resolution applicant, strategic investors, what is the debt to EBITDA ratio, sales ratio, financial investors can then talk about fund size, assets under management of resolution applicant. SPVs can talk about financial strength of the group or holding company. Various options of relative parameters would include then reasonableness of financial projections and likelihood of honoring proposed commitments, covering future business plan, risk assessment and mitigation plans. Qualitative parameters can then be external credit rating of the RA. It can be regulatory compliances of RA if resolution applicant is an SPV, track record of debt payment of resolution applicant, technological advancement introduced by the RA, future prospects. Quantitative parameters can be upfront cash recovery as per resolution plan. In many cases, this will be within the 60 days, first 60 days, whatever is being paid by the resolution applicant. Then it can be the remaining amount, that is the net present value of continuing portion of debt. That can be the second part. And the third part can be what is being paid to the operational creditors. Fresh equity infusion can be another one. Then change in portfolios of goods or services produced, then arrangement with the creditors of corporate debtor. All these can be part of your quantitative parameters. Then we can come to requirement of Rfrp under the code. And so RP is to issue the information memorandum, bid evaluation matrix, and request for resolution plan to list out the provisional prospective resolution applicants within 5 days from the date of provisional list. So IM, BM, and Rfrp to each PRA in the provisional list is issued, and to each any PRA who has objected to this exclusion from the list, they can be then shared the reason why they have been excluded, and they can be given an opportunity to correct their exclusion or correct their documentation which is resulting in their exclusion, and so on. So brief introduction about the corporate debtor that can be part of your Rfrp, corporate insolvency resolution process, details of the same, details of the IRP, the insolvency resolution professional, then reference to provision of the IBC, details of resolution process advisor, reference to provisions relating to expression of interest and its details, resolution plan process. All these things can be part of your RFRP, and these can be made part of the RFRP to the extent applicable to corporate debtor. So disclosures, confidentiality, notes to resolution applicants, resolution plan preparation cost, applicable laws. So these can be various parts that can be part of your part of your RFRP. Then RFRP can have these following annexures. It can have the evaluation criteria, contents of the resolution plan, format for bank guarantee, format for performance guarantee, undertaking by resolution applicant, format for power of attorney, format for power of attorney for lead member. So this way 29A affidavit. So these are various appendix or various documents that can be added. And then performance security. So like maybe Shalya can share a little bit about performance security and how that is important part of the entire process, and like in absence of which maybe the entire process can get derailed. So you can take over, Shalya.
Yeah, so performance security, that RFRP document provides for details of performance security required from successful resolution applicant. Now, this is important just to assess that when the plan is submitted by the resolution applicant, he is bona fide and he is going to implement the plan and he wants to pursue the plan. Therefore, he provides a performance security. This is basically some amount, the security is submitted in form of some bank guarantee. Then the time to be prescribed for providing such a performance security is to be provided in the RFRP. The performance security shall stand forfeited in case the successful resolution applicant fails to implement the plan or contribute to the failure of the plan as approved by NCLT. So as I said before, the performance security is submitted only to prove that the resolution applicant is going to implement the plan. So now if he fails to implement the plan, the amount which he paid as a performance security, that is forfeited by the resolution professional. Now, performance security can be of any nature, value, duration, for subject for that has to be approved by the CoC, and which depends upon the business of the corporate debtor. The performance security can be absolute term for X amount for Y years, or can be a percentage of amount offers to the creditor. So now this depends on the business of the corporate debtor and as approved by the CoC.
Right. So then modification in RFRP or bid evaluation matrix can be considered as fresh issue of RFRP and BEM, and minimum 30 days period would be allowed to each PRA after modification is issued. So therefore, it is also important to have these correct in the first instance itself. Otherwise, in case an RFRP or bid evaluation matrix is issued, which either sets criteria which are very, very rigid, which does not attract any resolution applicants, or on the other hand creates a situation where there are too many applicants and creates rather non-serious applicants to come in. So in either cases, this can be a problem. So extension of time for submission of resolution plan, any extension for submission of resolution plan can be granted with the approval of CoC. So that's of course there. Resolution plans received are not satisfactory. CoC can decide to ask all prospective resolution applicants to submit fresh resolution plans as the earlier ones are not up to their expectations. Meetings with prospective.
I think it's Ankit sir, internet there's a connection issue. Are we out of the webinar as of now?
Ankit sir is ready.
Yeah, so I'm back, but then I think we are also running short of time, and we are almost at the end of our presentation. So let me just resume the screen sharing and quickly discuss the last part of the presentation. Just a second. So, of course, the resolution plan cannot be accepted by RP unless CoC decides to close the existing UI processes, and this way the resolution process or the resolution plan needs to be bettered, and there are limited areas where that can be done. So, various options for a resolution plan. So, resolution plan can think of transferring all or part of assets of the corporate debtor to one or more persons. That is one way. And the creditors can do a one-time settlement, and the entire debt, including the right to invoke personal or third party guarantees, all this can be done. So key factors for taking this decision is present value of realization versus future recovery. Funds in recirculation is better than funds stuck. Uncertainties of future business plans. So this is a way where sale of then part B can be sale of all or part of the assets, whether subject to any security interest or not. Then part C can be substantial acquisition of shares of the corporate debtor or the merger or consolidation of the corporate debtor with one or more persons. Clause D, another possibility is satisfaction or modification of any security interest. This is also possible in the resolution process. Curing or waiving of any breach of terms of any debt due from corporate debtors is a possibility under resolution plans. Reduction in the amount payable to creditors is possible. Extension of a maturity date or change in interest rate or other terms of a debt due from corporate debtor is possible. Amendment of constitutional documents of the corporate debtor is possible. Issuance of securities of the corporate debtor for cash, property, securities in exchange for claims or interest or any other appropriate purpose is possible. Then uh, uh, these are all possibilities under resolution plans. And CoC is, of course, as we already discussed, is the supreme authority to understand the feasibility on how the company will best function uh, after the resolution plan is implemented. So, treatment of avoidable transactions, sale of FSI, FAR, or sublease of existing plot. So, these are some issues that need to be taken care of in the resolution plan. Uh, Selecting a resolution applicant. So, who all are not eligible to submit a resolution plan. 29A then talks about so many people who can't be. So, CoC needs to be vigilant that yes, none of the people who can get trapped as a related party or under section 29A should not be submitting a resolution plan. And all these elements are therefore important to be confirmed by the CoC as well, although the primary liability to conduct a thorough search is on the resolution professional. So no eligibility criteria recommended in the code or regulations. Eligibility criteria is something that is a popular issue, but then yes, the RP needs to understand the values of the assets of the CD, and based on that, fix up an eligibility criteria. It can't be too rigid. It can't be too easy. So maybe we can use this later. Valuation under IBC, as we have already said in the past, is very, very important. As we said, for CoC, the valuation is important because in case the assets are undervalued by the valuer, then it might give way for the resolution applicant to get the assets or to show that he is paying more than the liquidation value, whereas the liquidation value might be wrongly calculated on the lower end. And on the same side, in case the liquidation value is computed wrongly by the valuer at the higher end, then again that process derails the entire process, because in case the CoC then is not able to get approval on the resolution plan, which is offering an amount which is slightly less than the liquidation value, then again it results into a situation where that asset is not realizable. So in many cases, the CoC can go ahead and get an independent valuation done at their own end to make sure that they are getting more than the liquidation value, which their empaneled valuer is giving to them, even if the liquidation value computed by the registered valuer under the process is giving a higher value. So with this, the valuation reports, of course, are very important, very important part of the entire process. So with this, this entire presentation on how the CoC has powers, how the CoC can. So CoC does not have powers to appoint valuers, but the CoC definitely has powers to approve the amount which is payable to valuers, and the CoC can very well also oversee the valuation valuer appointment process to make sure that quality valuation is done for the assets rather than a passive one. So with this, we can conclude today's session. And thank you, Aditya. Thank you, Shalia, for being part of this session. And thank you, everyone,
Thank you.
for again encouraging us by coming and attending our webinars in large numbers. We will be back next week with another topic which should be interesting for all, and we'll continue this series in the coming weeks. Thank you, everyone. Thank you so much.